From the main list, item number 1.
Yes. Yes. Today there's a mistake in the list. I wasn't told, but I see now. At the end of the day, it's my responsibility. I should have seen. Because we called it the full bench, they've put up all 4 judges. Justice Bhattacharya can't be part of this because he appeared in some of the court matters.
Yes,
Full bench in a high court means anything over a division bench. It does not mean full complement of benches.
yes, sir.
If you have 62 judges in a court, it does not mean 62 judges sit to make it a full bench. There's a difference between a full bench and a full court, which I should have known that they don't know over here. So it's our mistake. The matter is listed before a wrong bench. So we will rise today. We can't take it up. It's irregular. The matter will be listed on Thursday before this bench. This full bench comprising the 3 of us.
Yes, sir.
My apologies.
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1. My lord.
Yes, what is the matter about?
This pertains to a tender process, my lord. My lord, I'm praying if this matter can be taken up tomorrow, my lord.
Very well, since one of us, bracket Patricia GJ, cannot take up this matter, comma, that will be placed before another division bench. The matter will appear a week
My lord.
before the state.
Lodge.
Yes.
Item number 2.
Much obliged.
Ma'am, please, your lordship.
Yes, madam.
Lordship, my senior is not present today due to some personal inconvenience. Kindly, the matter may be taken up after 2 weeks.
Why? We have
Lordship,
told you we
there's
throw
some
out the matter. No. No, madam, you are there. You do it. Despite the previous order of July 13, 2023, reflecting a prima facie view that the appeal would not be entertained since there was an efficacious alternative remedy available to the not appeal, that the petition would not be entertained because there was an efficacious alternative remedy available to the petitioners, comma, an adjournment is sought on the ground of personal inconvenience of counsel, paragraph, let the matter appear a week hence. Yes.
Item number 3.
One is an appeal, there is an application by somebody else.
My lord, that was, they took the plea of, one of the accused, my lord, took the plea of juvenility, my lord.
Very well.
That they could not establish, my lord.
Yes. This is section 50 not complied with.
42, my lord.
42 not complied with. What is the consequence?
Sunset and sunrise, my lord.
Yes. Open and shut. Is there anything else?
My lord, matter now revolves around that aspect only.
Yes. That's why we've given you time on several occasions that if there is a Supreme Court judgment, it's a very draconian law.
My lord.
And therefore, first there is the principle, Nazir Ahmed principle.
My lord.
When law requires something to be done, it has to be done in that way and in no other way.
My lord.
And when the statute is so strict, and the consequences are that you have to disprove,
My lord.
then if you don't comply with the conditions, then of course the statute does not fall into place, or the rigors of the statute do not fall into place. Now you have to only show us something to the contrary, whether of a High Court or of the Supreme Court. But this is dispensable to such extent.
My lord, I came across some decisions of Supreme Court, my lord, which says that if it is a gazetted officer who is doing the search and seizure, my lord, in that case, section 42 will. But we have not established anything that this
Is a gazetted officer.
is a gazetted officer, my lord. And moreover, he was exercising that power, my lord.
Absolutely, absolutely. We went through that. We went through the notification also.
My lord.
We could not establish that. So first it's facts. Thereafter it will be law.
My lord.
So you tell us, and that's the only way.
Because the interplay of 41,
You're not in.
you're out.
You're out. You're out.
But the interplay of section 41, 42 and 49 says, my lord, a conveyance on the highway, my lord. There is no bar of,
There are certain circumstances.
My lord.
For instance, a chance,
Section
accidental recovery.
49 covers that, my lord.
That will be, but when it's planned, then you have to do it in the way that the statute requires it, or the search and seizure is vitiated.
Well, moreover, my lord, last week a decision has come from Supreme Court, my lord. Of course, that was not the issue here. Because Supreme Court has said that because Section 52A now provides, my lord, that immediately after the recovery, my lord, the contraband has to be taken to the magistrate for sampling, my lord. And sampling has to be done in front of magistrate, my lord.
That was not there. That provision was not there.
Provision was there, my lord. But Supreme Court judgment in Mohanlal, state of Rajasthan, my lord, that has become a landmark in this, my lord.
Now,
my lord.
it's a recent judgment.
It's not very recent judgment, my lord, but that was not given effect in that sense, my lord, because there was still some ambiguity. But now, the last week Supreme Court has clarified that if sampling is not done before magistrate under Section 52A, this will vitiate anything, my lord.
You see, otherwise also, Dr. Modika, we are aware in other places, we are not saying whether it's out, we don't know what happens over here. In other places, it's used as an instrument of oppression. The same quantity is recycled through several people that you don't like, and several people are shown to possess the same. That's why the provision for sampling and also for destruction.
Well,
Tell us.
but I don't really have much to say, my lord. You will also dispose of today or maybe some other day, my lord.
You tell us.
I'm
Your
ready.
choice. Do you want him to come another day, or you're not from here?
No, I'm here from here, Lordship.
Oh, you're from
I'm
here.
Ceylon.
Then it's not no difficulty.
And moreover, he's out, my lord. So,
একবার দেখে নিও তাহলে নন কমপ্লেন্স কাগজটা পড়ে নিও দেখে নিয়ে একটা it's a judgment of acquittal. We also have to uphold acquittal. If you want, you can prepare your judgment. We'll keep it after 10 days.
my lord.
Let this be
My lord.
Justice Bhattacharya's first.
But we'll hear you. We'll hear you.
I can give a list of dates, my lord, is the important that will. And here I can give it to
Please do. Just give it to our officer. We'll take a look at it.
Here, my Lord, even not only 42.
Sorry?
Here in this case, my Lord, not only 42, even 42, Section 55, Section 52A, Section 57, none of the section has been complied here, Your Lordship. None of the section has been.
Those have been noticed in the trial court judgment.
Yes, Your Lordship.
All of those.
Yes, Your Lordship, and it has been accepted by the witnesses also. Even so-called IO of this case, who has been examined as PW8, he has clearly stated in his cross-examination that I have not complied the provision of Section 41 and 42 of NDPS. He has accepted, Your Lordship.
Very good.
My lord, one of the issues was that the 18 packets were seized, my lord, and the contention is the samples were drawn only from 4 packets, my lord. My lord, our case is that even 4 packets make out a commercial quantity, my lord.
Yes, that we remember.
My lord.
That we remember. But the gravity of the offence, the extent of the punishment will have to be based on a much lower level than originally charged with.
Well,
So that we look into. But if the basic thing has not been done, then everything goes. Recovery is in doubt.
my lord, in my humble submission, my lord, the quantity being so huge, my lord, if it was a case of some 50 grams or 100 grams of heroin, my lord, the planting can be suspected, my lord, but it is a seizure of 500 plus cases of ganja, and that also on source information, my lord.
With your experience, you will know that sometimes truth is stranger than fiction. So we don't know.
My lord.
Even if they don't have the independent witness also, Your Lordship.
No, that is all right.
Yes.
Very well.
I'll submit to the court, master, my
Let
lord.
the matter appear 10 days hence. Give the list of books. Brother will go through, and then we'll give one chance
My lord.
for both sides, and it shouldn't be too long.
Ask my lord when he wants the papers and then give the papers after they give the list of books. And then take it about it.
Not next week, the week after that. 10 days hence.